Thank you. If the state wishes to make an opening statement, it may do so now.
Thank you, Your Honor. May it please the court counsel. On the evening of September 22nd, 2024, in Farmville, Iowa, 17-year-old Michele Jackson was brutally killed in a vicious attack that shocked the small community of Farmville. Through the testimony of approximately 12 witnesses and compelling physical evidence, the state will produce evidence showing beyond a reasonable doubt that the defendant, Nathaniel Bevers-McGivney, committed murder in the first degree and abuse of a corpse as charged in the trial information. Your Honor, we often say someone is caught red-handed to mean they were caught in the act, so to speak. Here, Your Honor, the phrase is grimly literal. The evidence will show that Michele Jackson's blood was found on the defendant's clothing, on items he was caught removing from the crime scene, including her bloody shoe and a green electric scooter that she had driven to the park that day. And most crucially, on components of a Mossy Oak brand replaceable blade knife that was recovered from the defendant's apartment and person, directly linking him to this crime. The evidence will show that these events began around 8:30 on September 22nd, 2024, when Michele, who lived with her mother, Annette Jackson, told her mother she was heading to the Farmville City Park on the family's green electric scooter. The evidence will show that Michele was drawn to that park nearly every day, sometimes multiple times a day. It's the one place they say that she found solace swinging on the sole swing set working in the park. The evidence shows that these rusty chains affixed to the swing set produced a loud, distinctive squeak that echoed through the small town of Farmville, and that she would swing for hours there listening to music, immersed in just a solitary routine, and that this was a familiar sight, not just for the family, but for also the people in the small community of Farmville. The state will produce a security video from a home immediately adjacent to the Farmville City Park that captured but clearly shows a figure on a scooter passing by approximately 8:44 p.m., establishing Michele's presence en route to the park. Michele's mother will testify that she expected Michele home by 10 p.m. that evening. That when Michele didn't return, Annette, her mother, tried calling Michele's cell phone multiple times, got no answer, though the calls didn't go to voicemail. With limited physical abilities, Annette called her other daughter, Shauna Bachman, at around 10:25, asking Shauna to see if she could locate Michele. Shauna also residing in the city of Farmville, not far from the city park. Shauna Bachman, again, Michele's sister, testified that she left her apartment where her and her boyfriend, Jordan Trudeau Adams, resided at around 10:35. She made her way past the park to her mother's residence so that the two of them could get together and search Farmville for Michele. When passing the city park on her way to pick up her mother, Shauna will testify she caught a fleeting glimpse of a figure holding an object that caught her eye. And to Shauna, what she observed was unremarkable in that moment, and no cause for alarm yet, as no exigency had really entered Shauna's mind. Unable to find Michele near the park, driving through Farmville on her way to her mother's, she was unable to find Michele. When at her mother's, she picked her mother up, and the two began searching in Farmville for Michele in Shauna's car. The two headed back to the park area, checking the streets. And in Farmville, Your Honor, this is not a small town, a little bit over a quarter of a mile large. The two made another pass by the park and then headed south on Farnham Avenue. Eventually, the two turned left off Farnham Avenue onto Main Street, where shortly after making that left turn heading east, they observed a strikingly vivid green electric scooter, and it stood out unmistakably against the dim evening light. It's a scooter that is impossible to miss in that town, where no other vehicle has such a bold color or unique design. And it was then a surge of relief had coursed through them, believing, seeing the scooter, that they had glimpsed Michele walking with it. As they approached closer towards the next intersection, which was Main and Moulton, they found that the hopes that they had in finding her were misplaced. When they got to that intersection, they spotted the scooter, not with Michele, but a man pushing it. As they got closer to the man in the vehicle, though they couldn't make out many details about it, the light was dim, they'll testify. Annette got out of the car and demanded to know from this man where he got the scooter. He first insisted, "It's mine." But as they pressed, pointing out that its unmistakable features, including a basket in the back with a bungee cord that Annette had affixed to the scooter some time ago, was unmistakably the scooter that Michele had driven to the park. It was then that this man, that was later identified as the defendant, he shifted, claiming he had found it at the park and was returning it to the park, gesturing vaguely in a westerly direction, and it made little sense to to Annette and Shauna at that time. Unconvinced, they persisted, asking, "Where is the girl who took this to the park?" To which the defendant replied, "I didn't see any girl." The defendant then abandoned the scooter, did an about face, and headed west back down Main. And at this time, Shauna, sister, followed the defendant in her car, parallel with her window down, as he was walking on Main westerly. Behind Shauna was Annette, the mother, in the green scooter, and she was pushing it with her feet while she was sitting on it. While the confrontation at the corner of Moulton and Main was going on, Shauna had contacted her boyfriend, Jordan, and let him know the circumstances of what was going on. As they being Shauna and Annette, pressed the defendant for more information, Shauna will testify, and she said to the defendant, "I can't let you go, I can't let you leave. You had my sister's scooter and she's missing." And shortly thereafter, the sister, Shauna's boyfriend, who was on the phone with Shauna, made his way down from their home a few blocks away to the north and was carrying a pistol. When Jordan, the boyfriend, had made it to the scene, he had asked Shauna about the green scooter, which at this time had been leaned up against the fire pit, approximately where the defendant had stopped and the car had stopped on Main Street. The boyfriend, Jordan, had asked Shauna to go inspect the scooter to see if there was any damage. Shauna will testify that when she walked over to the scooter, she saw in the basket a shoe, a bloody shoe, and not just any bloody shoe, but Michele's bloody shoe. It was at this time that the boyfriend ordered the defendant to the ground, to which the defendant complied. While the mother and the sister were following the defendant prior to Jordan arriving, Annette, the mother, had contacted 911, and dispatch had sent a Calhoun County Sheriff's deputy to arrive and investigate. That Deputy Jason McKinney. And he'll testify that he arrived approximately 11:04 p.m. He got out of his car right on Main, right where the defendant had stopped. Shauna's vehicle had stopped in the middle of the road, and where the boyfriend Jordan was holding the defendant at gunpoint as the defendant laid on the grass. Before Deputy McKinney got out, he turned on the spotlight on top of his patrol cruiser and ordered the defendant up off the ground and asked the defendant why was he being followed? To which the defendant muttered the thing, and he pointed, gesturing toward the abandoned scooter that was by the fire pit. But as the defendant stood in the glow of the deputy's bright lights for the first time, everybody there was able to see that from knees to his shirt, the defendant was covered in what appeared to be blood. In fact, in the background of videos that we will play, you will hear Shauna and her boyfriend exclaim, "That's blood." And the video recording of Deputy McKinney's body cam will show the defendant nodding in agreement. It was at that time the deputy took the defendant into custody. The search for Michele continued. At this time, this is still a missing persons case. The evidence will show that in the search for Michele, law enforcement scoured the city of Farnhamville and had come to the Farnhamville City Park, same city park where Michele habitually would swing on the swing set. While there, they uncovered two large pools of blood, mere yards from the swing set, in an area where Michele often parked her scooter, along with some miscellaneous personal effects that had belonged to Michele. Law enforcement also identified from these two pools of blood a trail almost appearing as drag marks from the pools of blood stretching nearly almost 200 feet from that point to the southeast edge of the city of Farnhamville's park. Law enforcement's investigation also continued. It led them to the defendant's apartment at 702 Farnham Avenue, apartment 13. They executed a search warrant. They uncovered blood staining the kitchen, the bathroom, blood on a towel, and other incriminating components of previously mentioned mossy oak knife set, including a bent handle matted with blood and hair that was thrown in a trash can in the defendant's apartment. Law enforcement broadened their search of Michele across Farnhamville, which is again a close-knit community, barely 400 people. By the early hours of September 23rd, 2024, over 25 law enforcement officers from over 5 law enforcement agencies from the surrounding areas converged, canvassed the area, knocked on doors, conducted interviews, and executed additional search warrants. The evidence will show that at about 9 o'clock September 23rd at 9 a.m., an employee from Landis Corporation, a business, an agricultural business that sits in the far southeast corner of Farmville, a worker there, informed law enforcement that he found a rolling trash can that was out of place. The trash can didn't belong to Landis, and it seemed out of place. It was behind a couple of tractors and immediately adjacent to a cornfield that had abutted the Landis property. This witness will testify that he opened the can, observed, didn't really know what he was seeing, thought it was an animal, and upon closer inspection, believed he thought it might be a person. And so that Landis employee alerted law enforcement. Law enforcement arrived, they opened the rolling trash can and confirmed what everybody already knew to be the truth. The search for Michele was over. The missing persons investigation is now officially a homicide investigation. The rolling trash bin and Michele were sent to the medical examiner's office for autopsy. Calhoun County Deputy Jason McKinney will testify that law enforcement procured an identical Masio brand replaceable knife to understand its composition and components. He'll describe how it's packaged, sold, and the items that come along with it. A hunter orange handle, a black nylon sheath, a clear plastic storage box, and 3 interchangeable blades. Deputy McKinney will affirm that these components precisely match what was found in the defendant's possession. One knife found in the clear plastic box inside the defendant's apartment found during the execution of the search warrant. Another found in defendant's pocket after he was detained. The black nylon sheath also found in the defendant's apartment on the kitchen table. And leaving one of the 3 blades from this package kit missing. The question about, at that time, the question of its whereabouts were unknown. A DCI DNA criminalist will testify that the forensic analysis confirms that the blood stains, the pools of blood, the park's grounds, the scooter, the defendant's shirt, the bed knife handle discarded in the defendant's apartment, and the white towel hanging in the bathroom, the blood on those items all belong to Michele Jackson. But it's a testimony of Leilani Lint and Deputy McKinney that will be admitted through deposition testimony for the former that will shatter the community's belief that this was some random act of violence. From the deck of Leilani Lint's, the defendant's aunt's home, where the defendant resided for approximately 2 months, a mere 100 meters from the park, anybody sitting on the deck of Leilani's home, on her deck on the west side or the east side of her home that faced the park, would have had an unobstructed view to the swing set, which was approximately 100 meters from the deck. Dr. Jacob Smith's autopsy will testify and he will reveal the nature of Michele Jackson's injuries. Michele suffered a gaping 2 1/4-inch incised wound across her neck, severing both internal jugular veins, both carotid arteries, the hyoid bone, and cutting into the 4th cervical vertebrae, which in his opinion caused massive blood loss consistent with the pools of blood found at the park. In total, Dr. Smith counted and identified 26 stab wounds to Michele's head and torso, including a 4 8.5-inch deep wound to her upper back that had pierced her lung. But it was during the autopsy, when the x-rays were taken, that the final piece of this mossy oak replaceable blade knife set, the one blade that had yet to be found, was uncovered. The missing serrated blade was lodged deep within Michele's back, invisible to the naked eye, until revealed only through x-ray scans. Your Honor, the state will prove beyond a reasonable doubt that on or about September 22nd, 2024, the defendant acted willfully, stabbed Michele Jackson, causing her death, that he acted with malice aforethought, a fixed purpose to do harm, and a deliberate intent to injure, not in the heat of passion, but with calculated resolve. His actions were willful, product of fixed design, not accident. At the end of the case, we're going to ask that the court find the defendant guilty of count 1, first-degree murder, and count 2, abuse of the corpse. Thank you.
Does the defense wish to make an opening statement?
Yes, Your Honor. Your Honor, the one thing that the state left out in its last part of its opening statement was premeditation. And that's where the defense is going to ask the court to focus its analysis of the evidence as it comes in, both premeditation and deliberation. Those are two of the required elements for first-degree murder in Iowa. And all of the things that Mr. Smith talked about in terms of how this unfolded, and especially what the court can glean from what happened afterwards, weighs very heavily that this was not a premeditated, deliberate act, that this was a spontaneous outburst, that it was not pre-planned, that there were no eventualities made for what would happen afterwards, because there was no forethought given to the act. It was just a spontaneous outburst. So all of the things that Mr. Smith had talked about in terms of the fact that this is a very small town, we're talking about a half-mile square each direction. This is at a centrally located public park on 4 fairly well-traveled roads, just off of where the roads are at, where the public was passing by on cars. We've got decent lighting in the area, especially around the area where this event occurred. It was near a building. The attack happened on pavement, as Mr. Smith talked about. There were large pools of blood. No thought given to a more concealed location. They were easily discovered once law enforcement started walking around the park. We've got these drag marks that clearly show that the body was dragged to the trash can which he was placed in. And that's another thing that the court will hear evidence on from the homeowner who had that can. They just simply had it taken from their home that night. There was no forethought given what would happen afterwards. We've got other things that you can look at when you listen to the evidence that Mr. Smith talked about with the interactions between Annette Jackson, Shauna Bachman, when they're confronting Nathaniel about the scooter. He has no good answers. He has not thought up what to say in the event that he's confronted. He's giving confusing directions. He's talking about, living over in this direction and returning the scooter to the park, but he's not traveling in either of those directions. The scooter itself has a bloody shoe in it. And the point there, Your Honor, when you listen to the evidence, what's going to become clear is that after Michele was killed and the body was taken over to the Landis Co-op, Nathaniel at some point did go home because that's where the knife was found. While he's there, though, he doesn't take any effort to be discreet about what he had done in the home. Blood is readily apparent throughout the home. He doesn't change his clothes, but yet he goes back out to get the scooter. Okay, so again, there's no clear thought about what's going to happen, how he's going to deal with this situation, because none of this was pre-planned. There was no thought. They have very minimal connection between these two individuals. Yes, he did live with his aunt for a period of time, and she did live across the street from the park. There is no indication that Nathaniel ever made any comments about Michele. In fact, when the police do search warrants of his phone, things like that, there's no obsessive content, there's no references. I don't believe that either Annette Jackson or Shauna Bachman are going to identify any prior contact of significance between these two individuals. This was simply a target of opportunity. And so it becomes this question of why did this happen? And that's really not really why we're here today. Motive isn't a element of the offense, but obviously that's something that the court is going to wonder about. And that's why we're going to admit the deposition testimony of Leilani Lynn. And what you're going to see from that is that Mr. McGivney had an extremely traumatic childhood. And that's not going to excuse anything that happened. We're not presenting that as a defense. We're trying to present that as a logical explanation of what those types of events could do to a young child. The after effects of those could certainly cause an outburst like we see in this case without explanation. What had happened with Nathaniel as a young child, his mother was extremely neglectful and abusive. When he was just a few months old, he was removed from his mother's custody in Washington State and transferred to Iowa to his paternal grandmother's care. And she was married to at that time, not his biological grandfather, to a different person. He lived with them for a short period of time as an infant. And then at some point, was transferred back to his mother's care until about age 7. That intervening time, Your Honor, was extremely traumatic. It included events such as Nathaniel being placed in the trunk of a car and being driven from Washington State to Georgia. While he was in Georgia, he and his siblings were forced to hide under blankets while his mother had sex for money. At various times, they were chased by people with knives and guns. All through those years, subjected to terrible neglect and abusive conditions as a very young child. At about age 7, he comes back to Iowa to live with his paternal grandmother again and is adopted by that family. And that does give some stability, but it does not undo the trauma that had been inflicted upon him. And although one can understand parents' right to make choices at that point, they're the adopted parents. He was homeschooled in a very small community living outside of Gallery, Iowa. So limited ability to interact, to socialize, mostly just on weekends and in the summers through church activities, things like that. So what we're going to ask the court to do is just look at that for some perspective on this, and then weigh all of the evidence in this case that shows that this was a very haphazard and hurried effort to account for an act that he did out of spontaneity, with no forethought, with no deliberation, without weighing in his mind what the consequences could be. So, Your Honor, that's what we're going to ask the court to focus on. Certainly when we get to the end of this case, it's going to be the question for the court is going to be between second-degree murder and first-degree murder on that main count. We believe that the evidence is going to show and weigh very heavily to the fact that there was no premeditation, that there was no deliberation, that this was a terrible, terrible situation. And we don't judge first-degree murder or second-degree murder on the harm that it caused. This is an inexplicable act, Your Honor. And the court has the ability, I think, to set those parts of this case aside. It is terribly sad. It terribly tragic. But the court's duty here, under the law, as the fair judge of the evidence, is going to be to weigh whether or not those key mental elements were met by the state in their presentation beyond a reasonable doubt. And the defense will argue at the end of this, Your Honor, that especially on those two elements of deliberation and premeditation, that they have failed